An entire industry wants to charge you for your VA claim. The law says they can't. The one person who legally can does it for free. By the time we reach this decision, we have already done the work. Records locked down, file read, we know what is in it. So when we look at the help around us, we are not looking at it the way most are taught to. There is an ecosystem built to help veterans, and it exists for a real reason. The system is hard to navigate, people get lost, and this ecosystem catches them. We are not coming to it lost. We look at each role, understand exactly what it does, and decide what we actually need. The first role is the VSO, the Veteran Service Officer, an official representative, accredited to act on our behalf. They help us file the claim, track it, manage correspondence, and monitor deadlines. They are the recognized channel between veterans and the VA, and under 38 U.S.C. Section 5901, a VSO cannot charge a fee. Here's the relevance to us. Everything a VSO does bridges the gap between a veteran and a system they do not understand. The safety net for someone walking in without records, without their file read, without a plan. That is the position we made sure we are not in, so the gap the VSO fills is already closed. The VSO is legitimate, accredited, and free. We still do not hand off our claim. We occupy that role, ourselves, for direct real-time control. We know exactly what the official channel does, which is why we can step into it rather than outsource it. The second role is the disability attorney, a specialist in legal matters. When a claim stops being about evidence and starts being about interpretation, the attorney carries that fight. They know the case law and the appeals system and can contest at a level most veterans never could alone. And there is one thing to understand up front. Under 38 U.S.C. Section 5904(c), an attorney cannot charge for the initial claim only after the first decision once it moves into an appeal, with the fee capped and paid from back pay. An attorney is not built for the front end. They are built for the fight after a denial. The attorney is the tool for when the system gets something wrong, and the way we operate keeps us out of that situation entirely. We build the claim so clean and so complete that there is nothing left to argue because the evidence answers the question before it is asked. There are other places an attorney earns their fee, mostly under 38 CFR 3.105. Reopening a final decision from years back for a clear and unmistakable error, or carrying a denied case up to the Court of Appeals for veterans' claims. Each is a study in its own right, and if a decision ever does come back wrong despite a clean file, then we know the attorney is the right tool, and exactly when, after a decision, never before. The third role is the claims coach, a strategist for the unorganized. Their value is taking a veteran's scattered medical history and turning it into a coherent claim, pointing out which symptoms line up with which conditions, giving shape to a file that was a pile of paper. For a veteran drowning in their own records, that work has real value, and we are not going to pretend it does not. But here is the part the ads never mention. Unlike a VSO or an attorney, a claims coach is not accredited by the VA, and under 38 U.S.C. Section 5901, no one without that accreditation can charge a veteran to help build a claim. So when a coach charges to put your claim together, they are charging for work the law says only an accredited rep can do, work the VSO does for free. These services get around the law by calling what they sell consultation or coaching instead of claim preparation. The work is the same. Changing the name is the only thing that lets them charge you for it. We have already done the one thing a coach gets paid to do. By securing our records, reviewing our own file, and learning what the VA needs to see, we have already performed the strategic organizing that a coach would otherwise charge us for. The product is already built by us for nothing. Now, some coaches do operate in a narrow legal lane, charging only for pre-filing consultation or education, not for building the claim. That is a real service and its own topic, but it is not one we need because we have already done the work ourselves. The last piece of this ecosystem is not a person we hire, it is a document we can buy, and that is the Nexus letter. A Nexus letter is a written medical opinion from a provider that connects a current condition back to our service, the bridge between what happened to us in uniform and what we are living with now. It is real evidence, and in the right claim, it carries real weight, so we treat it seriously. Here is what we understand about it that most do not. A private medical opinion is evidence the VA must consider, as required by its own regulations under 38 CFR 3.159. But the VA does not weigh that opinion by who wrote it or who paid for it. It weighs it by the reasoning behind it. That part is settled law from a case called Nieves-Rodriguez, and it means a Nexus letter is only as strong as the medical explanation inside it. A letter built on a full review of our record, with clear reasoning, carries weight. A quick letter from someone who never read our file or treated us is thin, and a rater can see right through it. Because we kept our care unbroken and our record complete, our strongest nexus comes from the provider already treating us, the one who knows the full story, because they lived it with us on paper. That is worth more than any letter bought off a website. So, are there legitimate times to seek an outside opinion? Yes. When a credible independent provider truly reviews the record and writes a well-reasoned one, but that is its own topic. For us, the strongest nexus is already in our record, and that is the help ecosystem, the VSO, the attorney, the coach, and the Nexus letter. One stage of the larger process of taking full control of our claim, and we run every stage the same way. We approach the help around us knowing exactly what each role does and what it can charge, and we take only what we actually need. Before you go, in the description, there is a tool called the Help Decision Guide. You tell it where you stand, and it shows you which of these roles fits your situation and what each one can and cannot legally charge. It turns this decision into a clear call instead of a guess. It's built, it's waiting, it's yours. Use it. Before we close, nothing here is a promise of any particular rating. Every claim is different. What we give you is the cleanest way we know to execute. For Guard and Reserve, women veterans, step-by-step, or benefits news, subscribe to the channel that fits your fight. Next, we take everything we have built and turn it into a plan, deciding which conditions we lead with, in what order, and how each one connects to our service. Study the plan, follow the model.